Hello everyone, thank you for taking time out of your busy schedule to join us for this webinar. Today we're going to change the format a little bit, and instead of a lecture, we will be holding a mock trial. As you may know, due to the pandemic, Chinese courts have introduced and are utilizing online trial so that litigation cases can be heard timely without delay. This mock trial will be held as an online trial. Except for major cases, trials in China are usually heard by a panel consisting of 3 judges. The presiding judge oversees the entire process of the case, and the leading judge hears the specific issues of the case. Each party may request 1 or 2 counsels. In this mock trial, the panel, each party and their counsels will all be played by the attorneys from which law firm. The case being heard is actually based on the design infringement litigation case handled by the firm, which is an exemplary civil and administrative epic case of Shenzhen Court in 2021, for which we have obtained the consent of our client. By organizing this mock trial, we would like to introduce the procedure of online hearing of patent infringement lawsuit in China and the method of proving damages. If you have any questions, please send your questions to linda@lindapatent.com. Our attorneys will reply to you as soon as possible. Also, for better understanding, I would like to give a case brief. Background of the case. In this case, the Japanese company is a design rights holder. The product involved is popular in China and Japan. Since the second half of 2017, counterfeit products have been sold in large quantities on Alibaba and Taobao and have also been exported to Japan. The rights holder filed several rights infringement complaints to Alibaba and Taobao, but after the related link was deleted, they immediately created new links to continue selling and did not post the product's exterior drawing on the sales page, which makes it harder for the right holder to file infringement complaints. In order to thoroughly stop the infringement, the right holder entrusted us to file a design infringement lawsuit. The difficulty in this case, since the counterfeit goods do not have the manufacturer's mark, how to identify the manufacturer. Retrieving the sales volume data is extremely difficult after the link was deleted. So how did we deal with these difficulties? Identify the manufacturer based on the markings and their information on the product. We applied to the court for an order to collect the evidence and submit account books. The first instance judgment as follows. Ordering the defendant company X to cease the act of manufacturing, selling, or offering the sale to alleged infringing goods. Ordering the defendant company Y to stop selling or offering to sell alleged infringing goods. Ordering the defendant company X to pay the plaintiff economic losses and the reasonable expenses of 3 million Chinese yuan. Ordering the defendant company Y to pay the plaintiff a total of 200,000 Chinese yuan for economic losses and reasonable expenses. Both the defendants, Company X and Company Y, were dissatisfied with the judgment of the first instance and filed an appeal. This mock trial is the second trial of this case. So Clark, let's start the mock trial.
Now we are checking the identity of each party attending the court. Counsels, please show your lawyer's license in front of the camera. Okay, good. Now I pronounce the courtroom discipline. According to the rules of People's Court of the People's Republic of China, the following disciplines shall be observed. No audio, video, or photography. No moving around and entering the trial area at will. No speaking or raising question. No applause, clamoring, and other behavior that disturbs trial activities. Wireless communication tools shall be turned off. Those who break the courtroom discipline will receive oral warning, reprimand, and confiscation of their audio, video, and photographic devices. will be ordered to leave the courtroom or will be penalized or detained upon the approval of the president. Criminal responsibility shall be investigated against those who seriously disrupt the court trial order in accordance with the law. Presiding judge, please announce the opening of the court.
The court is now in session. Now verify the identity of parties and their counsels. Appellant A.
Appellant A is company X and its address is number X, Village F, Town F, Pingyang County, Zhejiang Province. Its legal representative is Mr. Lin. Its counsels are Rich Gao and Bo Xin, attorney at law from Beijing Gao and Xin law firm with special power attorney.
Appellant B.
Appellant B is company Y, and its address is B302Z Industrial Zone, L Road, P Street, Longgang District, Shenzhen, China. Its legal representative is Mr. Tao. Its counsel is Ming Yao, attorney at law of Beijing Injustice Law Firm with special power of attorney.
Appellee.
The appellee is company M and its address is DEC-ku, Nagoya, Japan. Its legal representative is the director, Mr. Matsushita. Its counsels are Sai Chen and Tao Chen, attorneys at law of Beijing Wei Jixue Law Firm with special power of attorney.
Appellant A, do you have any objections to the presence of the appellant B and appellee in court?
No objection.
Appellant B, do you have any objection to the presence of the appellant A and appellee in court?
No objection.
Appellee, do you have any objection to the presence of two appellants in court?
No objection.
The identity of each party and their counsels have been verified as correct. Each party has no objection to the other party's presence in court, and each party and their counsels comply with the provisions of the law and are permitted to participate in this lawsuit. Today is a public hearing of the design infringement lawsuit appealed by Appellant A, Company X, Appellant B, Company Y, against Appellee Company M through the Internet in accordance with the provisions of Article 176 of the Civil Procedure Law of the People's Republic of China. In accordance with the provisions of Article 40 of the Civil Procedure Law of the People's Republic of China, the panel is composed of the presiding Judge Peter Zhang, Judge Nancy Song, and Judge Joyce Zhang. In accordance with the law, Clerk Chris Doe serves as court assistant and recorder. The rights and obligations that the parties are entitled to in the action and court discipline have been served before the court, which will not be pronounced here again. The parties enjoy the right to petition for recusal of panel members. The appellant and appellee, are you clear about your rights, obligations, and court discipline? Do you file a petition for recusal, Appellant A?
Clear, no, we don't.
Appellant B?
Clear, no, we don't.
Appellee?
Clear, no, we don't.
Now we have Judge Nancy Song organize the court investigation and debate.
Appellant A, please briefly state your appeal claims, main facts, and grounds.
We request the court appeal to revoke the third item of first instance judgment and determine the compensation of less than 50,000 yuan. Appellant A advised that the court of first instance indirectly determined the appellant as the manufacturer of infringing products who shall bear the responsibility of producing the infringing products without investigating the actual manufacturer of the infringing products, rendering an error in determination of fact. Moreover, the appellant sold infringing products with the authorization by other party in accordance with the law, and appellant has already fulfilled its duty of care and has no subjective bad faith to infringe, so it did not belong to intentional infringement. Since no effective judicial or administrative ruling confirms whether or not the involved sales act constitute infringement, it did not constitute repeated infringement. The profit gained from infringement established by the court was much higher than the actual profit of the appellant might gain. The actual contribution of the product design to sales failed to be taken into consideration. Even if the sales act of the appellant constitute infringement, the damages for economic loss avoided were far more than the actual loss of appellee and a profit amount that the appellant might gain. Therefore, there is a serious error in the determination of facts and the application of law. Thus, we request the Court of Appeal to revoke the first instance judgment and make a new judgment on appellee's claim of economic loss.
Appellant B, please briefly state your appeal claims, main facts, and grounds.
The court of first instance was wrong in finding fact at the application of law. Appellant B had no subjective bad faith of infringement, and the goods appellant B sold had legitimate sources, as they were all purchased from appellant A. The amount of compensation claimed by the appellee was not based on fact and law. We hereby appeal to your court and ask your court to determine appellant B not to bear any liability.
I think your appeal claims needs to be further clarified.
Your Honor, I have a slide to share here. We request your court to revoke the fourth item of a first instance judgment and determine appellant B shall not bear any compensation liability.
Appellee, have you filed a written response? Please make a brief statement of your defense.
Yes, we have already submitted a written response, and the summary of our defense is as follows. Firstly, the evidence we have can prove that the appellant A is a manufacturer who conducted the act of manufacturing the accused infringing products, and the appellant A showed evident bad faith of infringement, and the infringement circumstance was very serious, so the compensation awarded by the court of first instance was fair. Secondly, the appellant B knew that the accused infringing products were suspected of infringing the appellee's patent rights, but continued to sell them, showing the bad faith of infringement, and appellant B did not submit any evidence of legitimate source, so the appellant B's defense of legitimate source cannot be established. The appellant B should bear the liability for compensation, and the amount of damage awarded by the court of first instance is fair and should be upheld.
Appellant A, do you have any objection to the fact that the alleged infringing product falls within the scope of protection of the asserted patent?
We have no objection.
Appellant B, do you have any objection to the fact that the alleged infringing product falls within the scope of protection of the asserted patent?
Appellant B is only a small seller. We don't have the ability to judge if there is infringement, so it's up to your court to make a determination.
Appellant A, do you have any objection to the fact that you conducted the acts of selling and offering to sell the accused infringing product?
No objection.
Appellant B, do you have any objection to the fact that you conducted the acts of selling and offering to sell the accused infringing product?
No objection.
Appellant A and B, do you have any objection to the trial procedure of the first instance? Appellant A,
No objection.
Appellant B,
No objection.
Appellant A, do you have any objection to the facts found in the first instance?
Yes, we have objection to the fact found in the first instance that we are the manufacturer and the objection to the profit we gain from infringement.
Appellant B, do you have any objection to the facts found in the first instance?
No objection.
Based on the arguments and response of each party, the disputed issues in this case are summarized as follows. Disputed issue 1, whether appellant A is the manufacturer. Issue 2, whether appellant B's defense of legitimate source is established. Disputed issue 3, whether the liability for damages determined in the first instance is fair. So all parties, do you have any objection to the disputed issues summarized by the panel for this case? Appellant A,
No objection.
appellant B,
No objection.
appellee, do you have any objection to the disputed issues?
No objection.
And is there any new evidence to be submitted in the second instance? Appellant A,
No, Your Honor.
appellant B,
No, Your Honor.
appellee,
Yes, Your Honor, we would like to supplement a new piece of evidence.
so what kind of evidence is that? Please explain the nature of the evidence and the purpose of the proof.
This evidence is a trademark information of appellant A's legal representative who registered the trademark Imayo, which shows that the trademark on the accused infringing product is a trademark registered by appellant A's legal representative, proving that appellant A is the manufacturer.
Why did you fail to submit this evidence in the first instance?
We did not find it in the first instance.
Appellant A, please state your cross-examination opinions now.
We do not recognize the relevance and purpose of the proof. The trademark is not registered by appellant A, and it has no relevance to this case. Thus, it failed to prove that appellant A is the manufacturer.
Appellant B, please make your cross-examination opinions.
The trademark registration information is in nature not a new evidence, not a new fact occurred after the first instance trial, which should not be regarded as new evidence and should not be admitted. We refuse to make cross-examination opinions.
Cross-examination now concludes. The following is the court investigation and the court debate, focusing on the disputed issues. Do you have any objections? Appellant A,
No, Your Honor.
appellant B,
No, Your Honor.
appellee,
No, Your Honor.
now appellant A, please make the statement on the disputed issue 1, whether the appellant A is the manufacturer based on the evidence.
Okay, with regard to the fact that whether the accused infringing products were produced by the appellant A, the appellee failed to fulfill its burden of proof, and the court of first instance should not simply presume that appellant A is the manufacturer of the infringing product. The reasons are as follows. Firstly, the packaging of the infringing product was not marked with the manufacturer's name and address, and the appellee did not provide any direct evidence to prove that the appellant A had actually produced the infringing product. Therefore, it should not be taken for granted that appellant A was the manufacturer of the infringing product. Secondly, the accused infringing product purchased by the appellee from the appellant A through two channels only used the appellant A's registered trademark Imayo on the packaging. The appellant A, however, only applied for trademark registration in China for the goods in Class 21, such as basin, drinking utensils, and did not enjoy registered trademark rights in the class of the infringing product. Under such circumstances, the higher possibility is that it is the out party who produced the infringing product using Imayo. In addition, it is known that trademarks have the function of identifying the source of goods, but the product marked with the registered trademark are not necessarily produced by the trademark right holder. There is a possibility that someone used the trademark without the authorization of appellant A. Thirdly, the natural person Mr. Zhou registered the trademark Imayo in Japan, and the designated goods are exactly the infringing product. In view of the fact that the accused infringing product involved in this case importing to Japan was returned by a Japanese customer, it can be proved that the natural person Mr. Zhou is the manufacturer of the infringing product. Fourthly, the appellant A is a township enterprise with a registered capital of only 100,000 yuan, which was established only 6 years ago on the date of the case, with little capital and small scale, and does not have the ability to produce and promote the infringing product on a large scale. Therefore, it is obviously impossible for the company to become the manufacturer of the infringing product in this case.
Okay, now appellant B, please make your statement on the disputed issue 1, whether the appellant A is the manufacturer.
Appellant B is only a small seller. We had no idea who the manufacturer is. We leave this point to your court to find out.
Now, appellee, please make your statement on the disputed issue 1.
Okay, we have a slide. In the judicial practice of intellectual property infringement cases, when the products are not marked with clear manufacturing information such as a name or the address, it is often necessary to combine the trademarks or other identifiable marks, production capacity, public information to determine the manufacturer. In this case, based on the evidence and the following reasons, it is proved that the appellant A is a manufacturer. First, Imayo is marked in many places in the package box and instruction manual of the accused infringing products, and the product title and brand introduction in the detailed information shown in the sales page in the store also contain Imayo, the English word and the Chinese character Imayo, but no other manufacturing information. With reference to evidence 12 in the first instance, upon searching the related trademark registration information of Imayo in China trademark searching website operated by Trademark Office of Singapore, we found that the appellant A has registered the trademark of Imayo in Class 21. And according to evidence 1 in the second instance we just submitted, the legal representative of the appellant A has registered the trademark of Imayo in Class 10, including body, building, massage equipment, and massage devices. Apart from this, no other enterprise or individual applied for registration of Imayo or any trademark containing email. Appellant A has only registered the 2 trademarks. So email is its only brand. In addition, a search of email in search engines such as Baidu did not reveal any information about any other companies using this trademark. Since no other company has registered or used the trademark email, it should be determined that email contained in the product titles and brands in the package, menus, and sales information of the accused infringing products all direct to Appellant A. 2. Appellant A opened a store on the Alibaba e-commerce platform under the name of its enterprise with a business model marked as manufacturer and shown as an exclusive cross-border supplier. The store also stated that the accused infringing products were direct sales by manufacturers and can be customized if a large order is placed. Thus, when Appellant A sold the alleged infringing products to the public, it already expressed itself as a manufacturer. 3. Although Appellant A denied that it manufactured the alleged infringing products, it did not and could not explain and prove the source of the products it sold. 4. Mr. Zhou, the right holder of Japanese trademark he mentioned, is an individual who apparently does not have production capacity. The search of the individual on search engines such as Baidu and the company information search websites such as Qichacha did not reveal any information about the establishment of the enterprise of the authorized use of the trademark by such individual. Appellant A also did not produce any evidence to prove that the alleged infringing products were produced by other domestic manufacturers authorized by Mr. Zhou. Moreover, the package of the alleged infringing products clearly states made in China, and the sales page also directly indicates that the products are domestic brands. So the marks on the products obviously does not direct to the trademark registered abroad. And according to the data provided by Alibaba, Mr. Zhou also purchased the infringing products from Appellant A's store. So it is impossible for him to be the manufacturer of the products. 5. In addition, the business scope of Appellant A covers the sales of daily necessities, the manufacture and sales of massages, fitness equipment, which means it has the production capacity to manufacture the alleged infringing products. Above all, it is apparently that the Appellant A is the manufacturer. That's all.
Appellant A, you claim that you are not the manufacturer of the accused infringing products. So what is the source of the products you sold? Is there any evidence?
The products are purchased from other companies. Appellant A is a company in a small scale. The management of the company's purchase was irregular, and the documents for the purchase of the products were not retained.
Appellant B, do all the products you sold come from the Appellant A?
Yes, they all come from Appellant A.
Appellant A, what is the relationship between the Japanese trademark holder, Mr. Zhou, and you? Do you know Mr. Zhou was doing the business of the accused infringing products?
No, Appellant A did not know the situation. Mr. Zhou registered this trademark in Japan, and the products are sold in large quantities in Japan. The said products may be operated by Mr. Zhou.
Your Honor, the reply of the Appellant A is inconsistent with the fact. According to the sales records from Alibaba, Mr. Zhou has purchased the infringing products from the Appellant A for many times.
Appellant A, is that true?
A lot of people purchase products from us, and we don't know these people.
I believe, any opinion on this point?
And No matter whether appellant A knows Mr. Zhou or not, Mr. Zhou has purchased the products from appellant A for many times, which shows that the infringing products Mr. Zhou operates also come from appellant A. So Mr. Zhou is impossible to be the manufacturer, and the appellant A is the source of the infringing products. That's all.
For this disputed issue 1, does any party have anything else to add? Appellant A,
Yes, Your Honor, we want to emphasize that the appellee claims that we are the manufacturer, and appellee should provide sufficient evidence. However, the appellee only provided a trademark registration certificate. Whose goods could not cover the alleged infringing products, so it cannot be presumed that the appellant A is the producer. The appellee should bear the burden of failing to provide evidence.
appellant B,
Nothing to add, Your Honor.
appellee,
The reason that we claim that the appellant A is the manufacturer is not only the trademark registration certificate, but also that the appellant A presented itself as the manufacturer in selling the products. In addition, the appellant A did not reasonably explain and provide evidence on the source of its products. Obviously, it's highly possible that appellant A produced the alleged infringing products. Moreover, in a typical case published by the Supreme Court, it was established that the defendant's self-proclaim in the advertising could serve as a basis for admitting the act of manufacture when the legitimate source could not be adequately verified. This is precisely the situation in our case, where appellant A can be determined as the manufacturer in view of the typical case published by the Supreme Court.
okay. Now for the disputed issue 2, each party may express your opinions based on the evidences. So first, appellant A,
The issue is not relevant to appellant A, and we have no opinion.
appellant B,
Your Honor, I have a slide to share. All our products sold in Alibaba store were purchased from appellant A, and we have paid a reasonable price for all the products. The trading chain was complete and in line with the general business practice. According to the sales records from Alibaba, it can be seen that we have purchased products from the appellant A for many times. We are only a small seller. We have no ability to judge whether there is infringement. Appellant A had provided us with a letter of authorization showing that he was authorized. Appellant B had no idea that the accused infringing products constitute infringement. We should be regarded as a bona fide seller, and our defense of a legitimate source should be established. Thus, we should not be liable for compensation.
appellant B, are you showing the correct slide just now?
Yeah, this is a slide.
Okay. Appellee,
We have a slide to share. According to patent law and interpretations of the Supreme People's Court, the elements of the defense of legitimate source are: first, the source of the alleged infringing products is legal, which means that they are purchased from legitimate purchase channels at a reasonable price. Second, the users, the sellers, and the offerer of the alleged infringing products have subjective goodwill and do not know or should not know that the product is infringing. In this case, the appellant B did not submit any document to the court to prove that the alleged infringing product had a legitimate source in the first instance. Even if it purchased the alleged infringing product from the store of appellant A of the first instance, it's not bona fide seller, and its defense of legitimate source could not be established. The appellee's evidence 14 showed that in 2018, the appellee filed 3 complaints against the appellant B's sales links for the alleged infringing products, and all the results of the 3 complaints were approved. At latest, at that time, the appellant shall have known that the existence of the appellee's patent involved in this case and the alleged infringing products sold by it are infringing. However, after the appellee filed the complaints for the infringement of the design patent, the appellant B still repeatedly put new product sale links, and in response to the complaints from the respondent, the appellant B deliberately continued to sell the alleged infringing products by not publishing product photos. Therefore, appellant B is not a bona fide seller, and its defense of legitimate source is unfounded. Appellant B shall be liable for compensation. That's all.
Appellant B, have you ever received complaints on the e-commerce platform? And were you still selling the products after the complaints has been established?
It was true that we have been complained on the e-commerce platform, but Taobao is not a judicial authority. The establishment of the complaint does not mean infringement is established.
Appellant B, you should have provided evidence of your product purchases to support your legitimate source defense. Did you provide any evidence in this case?
Although we did not provide any evidence, the sales data obtained from Alibaba can prove that we indeed purchased those products from appellant A.
For this disputed issue too, does each party have anything else to add? Appellant A,
We have nothing to add, Your Honor.
Appellant B,
Nothing to add, Your Honor.
Appellee,
We would add to that appellant B mentioned that appellant A provided a letter of authorization, but in fact, this letter came from an outsider who applied for the patent later, not the patent of this case. Moreover, appellant B and appellant A both submitted this authorization letter as evidence when appealed during the complaint process of the e-commerce platform. But the e-commerce platform ruled that the appeal was not approved. The complaint was established and asked the appellants to immediately remove the products. Although the e-commerce platform is not a judicial authority, the above process is sufficient to prove that appellant B is aware of the existence of the patent, and the letter of authorization provided by appellant A is unable to be a legal basis. Moreover, the accused product is identical to the design, and it's clear that it constitutes an infringement. Appellant B cannot make an excuse that he does not have the ability to judge. It should have been fully aware of the risk of infringement, but it continued to sell the alleged infringing products after the sales links are taken down 3 times. In order to avoid being discovered, appellant B kept posting new sales links without publishing product photos, which is sufficient to prove that it has subjective malice of infringement, and it's not a bona fide seller who can claim the defense of legitimate source. That's all.
Okay, so let's look into the disputed issue 3 now. Before the parties express opinions, the court would like to confirm some facts. Appellee, in the first instance of this case, you petitioned for the court to access the data of the e-commerce platform. So when did you file that petition? And what were the grounds and results of your petition?
We filed the petition for obtaining evidence from e-commerce during the time period for producing evidences of the first instance. The grounds are as follows. We preserved the sales pages of the alleged infringing products several times. However, due to our repeated complaints before filing the lawsuit, the sales links of the products were removed several times, and the relevant sales records could not be confirmed and counted. Therefore, we requested the court to obtain complete sales data from the e-commerce platform. After the court hearing, the court approved our petition for obtaining evidence and retrieved the sales data of the relevant products of appellant A and appellant B stores from Taobao platform. Based on the data we retrieved, we were able to identify the sales record of the alleged infringing product from September 2018 to 2020 of the stores of 2 appellants, which proves that the sales profit should be hundreds of thousands of yuan. However, the Taobao platform only stores data for 3 years, so the sales data before September 2018 is still not available.
You also petitioned for the documentary evidence discovery order. So when did you file that petition and what were the grounds and results of the petition?
When we sued in the first instance, we had already clarified the basis of calculating of defendant's profits from the infringement in the petition and provided the corresponding preliminary evidence. We also clearly stated in the petition that according to Article 27 of Interpretation of the Supreme People's Court 2, we requested to the court to order the defendants to submit accounts books and materials related to the profits from the infringement. During the court hearing of the first instance, the court asked appellant A whether it could show the back-end sales records in the e-commerce store, but appellant A refused. As above mentioned, although we retrieved the sales data of the relevant products from Taobao platform, the Taobao platform only stores data for 3 years, so the sales data before September 2018 is still not available. The alleged infringing product began to be sold in 2017 and was sold in large quantities until September 2018, and this part of the data can be queried in the back end of the appellant A store. Therefore, while cross-examining the evidence obtaining from Taobao platform, we filed a petition for documentary evidence discovery order to the court of the first instance again. And the court of first instance made a ruling ordering appellant A to provide the back-end data of its store, but appellant A refused to provide it.
Appellant A, is what the appellee just stated a fact? Did you refuse to provide the data during the court hearing of the first instance, and then refuse to provide it after the court issued a ruling?
During the court hearing of the first instance, our attorney just said it was difficult to provide the data because there were many business secrets in the backend data, which were managed by the party itself, and it was difficult for attorneys to show them during the hearing. When the court of first instance made the ruling, it has already obtained the data from Taobao, and we didn't think it is necessary to provide duplicated data again.
Okay, now let's come to the disputed issue 3. There are actually 2 issues. One is whether the liability of appellant A as found in the first instance judgment is fair. And the other one is the liability of appellant B as found in the first instance is fair. So first, regarding appellant A's liability, each party should present your opinions based on the evidence. First, appellant A.
Yes, we have slide to share. First, the appellant liability should not be liability should not be aggravated. We have three reasons for this. Firstly, the appellant began to sell the alleged infringing products after the products were authorized by the patentee, Mr. Yu, in accordance with the law. The appellant does not have the intent of infringement. The outsider, Mr. Yu, applied for a design patent for the appearance of the alleged infringing products in November 2017 and was granted on April 6, 2018. The appellant began to sell the alleged infringing products on the internet platform after making it clear that the appearance of the alleged infringing products was a product authorized by the obligee, Mr. Yu, according to the law. Secondly, as a township enterprise, the appellant was not long established and did not have its own factory or production capacity. Its main business was to sell products. Limited by the size of the company, it is impossible for it to hire a professional intellectual property search and analysis team like ordinary manufacturers to conduct a detailed legal analysis on whether the products it develops and the product and produce have patent infringement risks. In particular, Mr. Yu's design right is granted by the CNIPA, and we have trusted the authority of the CNIPA. So we believe that the sales of related products is lawful. Thirdly, before the case, there was no effective judgment or administrative ruling that the alleged infringing products infringed the appellee's design patent right. The complaint handling results of Taobao platform also do not have any judicial effect. In practice, it is very common that Taobao platform to misjudge the complaints. So we think it cannot be determined that the appellants committed infringement repeatedly and have bad faith. Therefore, for sales enterprise of the appellant side, it does not have any malicious intention to sell the infringing products legally authorized by others without the premise of legal determination of infringement by the court. It is obviously unfair to the appellant that the court of first instance increased civil liability of the appellant, referring to the malicious infringement and repeated infringement.
Regarding the profit of the appellant A from infringement determined by the Code of First Instance, we believe it is inconsistent with the fact. According to Taobao's response letter, the Code of First Instance concluded that the profit per product is 35 yuan, taking the appellant average selling unit price of 50 yuan during this period and subjecting the lowest selling price of other stocks of 15 yuan. According to this calculation, the appellant A sales profit during this period was 6,581 pieces multiplied by 35 yuan, equals about 230,000 yuan. The appellant A believes that the calculation is inconsistent with the fact and does not conform to commitment. Fourthly, the sales price as low as 15 yuan is only the behavior of individual stores, and the price of 15 yuan accounts for a very low proportion of all sales prices. Secondly, it is impossible to confirm whether the products actually sold by other stores are the alleged infringing products. So the cost and average price of the alleged infringing product cannot be calculated according to the relevant store's sales price. Thirdly, even if other stores sell the alleged infringing product, 15 yuan is far below the cost price, and their purpose is to attract customers, which cannot reflect normal sales conditions. Therefore, 15 yuan cannot be used as the cost price of the alleged infringing product. Fourthly, design is only a reference element for consumers to choose and buy the alleged infringing product, not a decisive factor. Whether consumers choose the alleged infringing product face slimming machine is ultimately determined by whether the product can meet their needs, especially the fact slimming function. This function is obviously not determined by appearance. Therefore, when calculating the appellant A's profit, we should consider the contribution of the design to the product sales instead of simply deducting the cost. Fifthly, as mentioned above, appellant A began selling the alleged infringing product as early as April 2018. In the nearly 14 months from September 2018 to August 2020, the court found that the appellant A made a profit of 230,000 yuan, while in the short 8 months before September 2018, the court found that the appellant A made a profit of 2 million yuan. It is obviously did not conform to the general business rules and logic. Appellant A is a small and micro enterprise. The accused infringing product is also cheap, and the profit of 3 million yuan is obviously inconsistent with the profit level of small and medium-sized enterprises. Therefore, the compensation liability of 3 million yuan undertaken by the appellant A decided by the court of first instance was far higher than the loss of the appellee, which did not conform to the general principle of assuming civil infringement liability and should be corrected. That's all.
Then appellant B.
We have no opinion on appellant A's liability.
Appellee.
We have a slide to share. Appellant A's claim could not be established for the following reasons. First, the appellant A had the subjective bad faith of infringement. The circumstances were very serious and had the factual and the legal basis for increasing the punishment. Although the appellee did not request punitive damages due to the reason that the time of the occurrence of this case is before the revision of the patent law. At that time, the punitive damages system had not been introduced in patent infringement cases. So the appellee did not seek punitive damages in this case. However, there is a judicial regulation that liability for damages should be aggravated in this case of bad faith infringement and serious infringement. The relevant provision regarding bad faith and serious circumstances in the interpretation of the Supreme People's Court on the application of punitive damages in the trial of civil cases of infringement of intellectual property rights can be applied by reference. In this case, appellant A directly used the introduction texts and graphics of the patented product in its store and hyped it up as the new face-slaving gadget from Japan, which indicates that appellant A apparently knew the existence of the patentee and the patented product. Furthermore, after being complained about many times and the appeal failed, it still did not stop listing new links and deliberately did not display photos of the allegedly infringing products to evade infringement liability, which is obviously against the principle of good faith. Moreover, the alleged infringing product is almost indistinguishable from the patent involved in this case, and it belongs to the literal infringement. As long as the ability of an ordinary consumer is available, it can be judged whether infringement is constituted. And appellant A's defense of not having bad faith on the grounds that it does not have the ability to judge obviously cannot be established. Moreover, appellant A also refused to carry out the court's discovery order in the course of the litigation and failed to submit the data within the prescribed time limit. And the infringement lasted long and the infringing product was sold abroad, which is obviously that the circumstance is serious. As such, the court have a factual and a legal basis to increase its punishment. 2. Appellant A's profit from infringement that the court of first instance determined was proper. At the stage of first instance, in order to ascertain appellant A's profit from infringement, the court of first instance ordered appellant A to provide its real books, contracts, delivery bills, invoices, and relevant electoral data that recorded the number of sales and profit of the allegedly infringing products. However, appellant A refused to provide relevant documentary evidence without justifiable reasons. Based on the sales records of the relevant links provided by Alibaba and the prices recorded in the sales links of the allegedly infringing products preserved by the appellee, the court of first instance deduced appellant A's profit from the infringement, which was completely reasonable. The amount of profit from infringement is calculated based on sales volume and the sales price. The store is appellant A's Taobao store. For the profit gained from infringement after September 2018, it's reasonable to presume the sales volume based on the sales records of the relevant links provided by Alibaba, and to calculate the profit per single product by subtracting the lowest price of 15 China yuan from the average sales price of the Taobao store during that period. Appellant A argued that the product cost should not be calculated as 15 China yuan. However, the relevant store showing the link to the lowest price product at 15 China yuan was not a third-party store, but rather appellant A's own Taobao store. It's really reasonable to estimate appellant A's costs by reference to the sales value of that store. Therefore, there is a sound basis for calculating a profit of 230,000 China yuan based on the sales volume for the period multiplied by the profit, 35 China yuan for a single product. Before September 2018, it fell under the peak sales period for the accused infringing products. According to the sales volume data recorded by the appellee, the average monthly sales volume during period reached 2,500 pieces, and the total sales volume was about 40,000. In addition, a single product can be highly profitable because of the high selling price for that period. So it's possible that appellant A's profit could reach 2 million China yuan. Therefore, the liability that appellant A should bear in the judgment made by the court of first instance is reasonable and legitimate. That's all.
Now, regarding appellant B's compensation liability, each party shall present your comments based on the evidence. Appellant A,
The appellant B's liability has nothing to do with us, and we have no opinion.
appellant B,
Your Honor, I have a slide to share with. We think the amount of damages which should be borne by appellant B determined in the first instance is unreasonable. The detailed reasons are as follows. Number one, the appellant B had no subjective benefit of infringement. Although the accused infringing product is similar to the patented product in appearance, the appellant B had no idea that the design of the accused infringing product fell within the scope of protection of the design patent in the whole course of sales. Number two, all our products were purchased from appellant A. As a small seller, it is indeed impossible for appellant B to know that the products he sold infringed others' patent. It should be determined that products sold by appellant B have a legitimate source. According to Article 77 of the patent law, appellant B should be exempted from liability. Number three, the appellant B had actively taken measures and stopped the infringement. The appellant B immediately removed the infringing products from the Alibaba platform when this case was started, and had never again carried out the acts of selling and offering to sell the infringing products involved in this case. Number four, the first instance court presumed that the appellant A had made a profit of approximately 230,000 yuan from infringement in nearly 3 years. Appellant B, as a customer of appellant A, purchased products from appellant A first and then sold them out. In this process, a sales link was added, and the profits appellant B obtained were certainly less than the profits obtained by appellant A. The presumption of the first instance court was obviously unreasonable and not in line with the normal business practice. Besides, the first instance court presumed appellant B made a profit of 20 yuan from selling of each single product, which was obviously inconsistent with the fact. In fact, appellant B only had a profit of approximately 4 yuan from selling of each single product. The actual product obtained by appellant B was much lower than 200,000 yuan. The amount of compensation 200,000 yuan to be borne by appellant B ordered by the first instance court was obviously unfair. That's all.
appellee,
We have a slide to share. Appellant B's appeal claims are also untenable due to the following reasons. In this case, according to the sales records of the relevant links of the alleged infringing products provided by Alibaba, the appellant's selling price for the alleged infringing products was actually 55 China yuan per piece. And the selling price before May 2019 could reach 58 China yuan per piece, which was much higher than the minimum selling price of 38 China yuan per piece of defendant A in the first instance. The appellant, as a selling store, did not have to bear the costs of the products, packaging, logistics, and storage, and it was completely reasonable for the court of first instance to presume that the appellant made a profit of 20 China yuan per product. The appellant claimed that the profit of each sold product was approximately 4 China yuan, but failed to provide any evidence, and it should bear the consequence of failing to adduce evidence. According to the sales data of the appellee's statistics, the appellant's sales volume within 2 years can reach more than 20,000 pieces, which can be deduced that its infringement profit may be as high as 400,000 China yuan. The court of first instance comprehensively considered the benefits obtained by the appellant due to the infringement, as well as the duration of the infringement, the nature of the infringement, the circumstances, the reasonable rights protection costs incurred by the respondent to stop the infringement, and other factors, and ordered the appellant to bear the compensation liability of 200,000 China yuan, which has a factual and legal basis. Therefore, the amount awarded by the court of first instance to appellant B was proper and should be upheld. That's all.
Regarding this disputed issue, does any party has anything else to add? Appellant A.
Your Honor, the price of this product is merely dozens of yuan. And as you know, the profit for products sold on Taobao are very low. How many pieces to sell for a profit of 3 million Chinese yuan? It is obviously too high, without no doubt.
Appellant B.
We are only a small seller with a very small sales amount. The amount of compensation in 200,000 yuan is indeed too high and unreasonable.
Appellee.
As mentioned previously, both appellants have obvious bad faith of infringement, and both of them continue to put on new links when they are aware of infringement and have been complained about many times. They even use various means, including not directly displaying the pictures, but continue to list the alleged infringing products. This is enough to show that the sales of the alleged infringing products have huge profits, which makes the two appellants willing to take the risks to break the law. Moreover, although Taobao platform regularly deletes sales data, Taobao stores themselves can retrieve all sales data from the store backend. This part of the data has not been deleted by the Taobao platform and will never be deleted. Therefore, appellant A has the ability to prove. Both appellants refused to provide their sales data at first instance, which is sufficient to show that after consideration, they clearly know that if they provide backend sales data, the disclosed amount of sales should be higher than the amount claimed by the right holder. The two appellants have no fear of the law at the time of infringement, committed the infringing act, refused to cooperate in the course of the first instance, ignored the court's documentary discovery order, and when they were to bear the legal responsibility, they began to complain and try to evade responsibility. We would like to require the panel not to be blinded by their rhetoric. That's all.
Regarding the facts of this case, now parties may raise questions to other parties. Do you have any questions to raise?
Yes, we have one question for the appellee. Why did you never purchase the appellant A's products?
The appellee has not authorized the purchase of products from appellant B, and also authorized appellant A's store's situation. Based on the evidence available, there is no need to further purchase products from appellant A again, as it has been able to prove the manufacture, the sale, and the offer to sell the active infringing activities from conducted by the appellant A. The appellee will obtain evidence that is necessary, but the purchase of products from appellant A is not a necessary action for the right enforcement.
Does the appellant A have further questions?
More questions, but we would like to emphasize the appellee never even purchased any products from the appellant A. However, the appellee has always alleged that the appellant A is the manufacturer. This is groundless, and we would like to emphasize this issue.
Does appellant B have any questions?
No, we don't have any question.
Appellee, any questions?
Yes, we have one question for appellant A. Appellant A claimed that his company is not the manufacturer, but he did not keep any evidence for the arrange, but he should be able to provide the name of the company from which he obtained the products, right?
Our e-commerce store sells a variety of products, but the alleged infringing products account for only a very low percentage of the appellant A's overall sales volume. And according to the appellant A, that was 3 years ago, and he has forgotten about it, and there were no records at that time. Therefore, we cannot provide any information at that time.
Does the panel have any questions?
Yes. Appellant A, can you provide the current sales data of your Alibaba store?
The store was closed, and we cannot provide any data.
Appellant A, have you closed your store and stopped manufacturing and selling the product in question?
Yes, they have done so.
Appellee, do you agree with this statement?
Disagree. Appellant A actually also has a Taobao store in the name of its legal representative that continues to produce and sell the accused infringing products.
Appellant B, have you stopped manufacturing and selling the accused infringing product?
We stopped manufacturing a long time ago. We don't have any manufacturing. We stopped our sales a long time ago.
Appellee, do you agree?
It's true that appellant B's Alibaba store has disconnected with the sales of the alleged goods, but there is a possibility these goods were sold in secret.
In view that the court investigation and debate have just concluded together, no debates will be organized separately. All parties should make your final statement.
We insist the claims in the appeal.
Our appeal claims remain unchanged.
We request that both appellants' appeals be dismissed.
In accordance with the provisions of civil proceeding law of People's Republic of China, the court may conduct mediation if both parties intend to settle before making judgment. Appellants and appellee, do you intend to mediate?
Yes, we have the intention to mediate. The compensation awarded in the first instance is groundless and excessive. Therefore, in case of mediation, we can pay 50,000 yuan, and we could not offer any higher.
Yes, we still agree to mediate.
The appellant's bad faith in infringement is clear, and even now it does not admit their infringement. As such, we cannot settle.
Since the appellee does not agree to mediate, the court will be adjourned here. And after deliberation by the collegial panel, the court trial will continue. Okay, let's continue the hearing. With regards to the subject case, following today's court investigation and debate, the collegial panel has deliberated as follows. 1. Based on the evidence in the case, the mark on the alleged infringing product and the promotional content of appellant A could show that appellant A's manufacturing act is of high degree of probabilities, and appellant A cannot explain or adduce evidence on the source of his product. As such, it was not improper that the court of first instance found that it has carried out the manufacturing act. 2. Appellant B continued to sell the allegedly infringing product, despite multiple complaints as a link to the alleged infringing product had been removed multiple times. It was not a bona fide seller, and its defense on legitimate source could not be established. 3. Based on the data retrieved from the e-commerce platform and the conduct of the two appellants in the litigation, the first instance judgment found that the two appellants had bad faith, as the nature of the infringement was heinous, which is not improper, and the determined amount of compensation borne by the two appellants was reasonable and legitimate. Pursuant to the provisions of the relevant laws, the judgment is made as follows. Dismiss appeal claims of both appellants and uphold the judgment of the first instance. The court fee for appeal shall be borne by the appellant.
Okay, today's session is now closed. Each party, please check the record before you sign.
This is the end of today's mock trial. Thank you so much for your participation. Your continuous attention to our following webinars will be much appreciated. Thank you.